I'm so pleased to be here with you, and congratulations on your election and the services that you're going to be providing for another 4 years. Challenges you're going to face, and I hope they're all as successful as you had hoped they would be when you ran. With that, I got a call from Ted, but I took the talk on land use issues for you all. And most of you know me as an employment attorney. Many others of you may know me as County Attorney of Brunswick and a few other attributes. But before I ever went to law school, I got a master's in planning. And it was my interest in planning that led me into law. And the reason that planning was so fascinating to me was, and I don't do well on clickers, so there. And I'm going to talk basically on the legal issues, is that nowhere more than in planning and land use issues do your actions as government officials impact constitutional rights of individuals. And so fundamental to all of us is our right to own property, to enjoy it, and to do what we want with that property, and not to have government intrude into that property right. And I also have some First Amendment rights. Should I be allowed to make my speech on my house if I want to put a big sign on my lawn, for example? I have the Fourth Amendment rights. If you're going to take my property away, I need notice. You just can't come and take my property or my enjoyment of my property, and nor can you do it after you've given me notice without giving me some opportunity to be heard. So throughout the presentations today, we are going to be emphasizing to you how these constitutional protections need to be incorporated in by statute in Virginia are. For example, on zoning. If there's going to be a rezoning, you have a certain time period where notices have to be given, it has to be open to the public, and you have to have public hearings. Public hearings are given the opportunity to be heard. So it's this interface of so embodied in all of us is my right to do what I want with my own property. But then my right to do with my property should not intrude in my neighbor's rights. And that's where much of land use came in. We wanted safety issues. We didn't want buildings put so close to one another that the fire department couldn't come in and save my building from the fire of my neighbor. So all of this was the beginnings of land use regulation. And it really only started 1900s, early 1900s. So you're not talking of something that's been around for a real long time. I just went over this. I have a constitutional right to use and enjoy my property. However, the extent of my enjoyment cannot intrude on my neighbors. And I'll tell you two things I do not want. I can tell you many things, but I can tell you two things, for example, that I wouldn't want as my next door. I don't want a lard processing plant. It stinks. And I want the breezes to flow through my house. And if a lard processing plant came in, I would come to my government and say, why did you allow it? I can't enjoy my property. I wouldn't want a demolition plant, metal demolition plant, for the same reason. What is it doing? The noises and light from that are intruding into my enjoyment, and who do I turn to? The people who allowed it in, the government. So you're going to be balancing this issue over and over again. Government can only restrict private use of property if the actions are not arbitrary and capricious, and those are two words you're going to hear over and over. That means do you have a basis in fact for your decision? That is not something fabricated. And that notice has been provided. You've got to tell me if I'm going to have some intrusion in my property, and that I've also had that opportunity to be heard. The general purposes, both under statute and constitutional planning, are to improve the public health, safety, and welfare. So whatever you do to restrict my rights and other people's rights to property has to be based on the premise that it is done for health, safety, or the welfare of the community. And it's to prepare for the future, adequate highways, recreational facilities, and to make growth in the community consonant with the efficient and economic use of public funds. You do not want a village to be created of 4,000 homes and have people clamoring to bring you then water and sewer when you do not have a budget to do it and you didn't plan on doing it as a government. So planning also helps establish where concentrations of growth will occur. The comprehensive plan is one document along with subdivision ordinance and a capital improvement program that every jurisdiction must have. So you don't need zoning, but you must have a comprehensive plan, you must have a subdivision ordinance. Subdivision ordinance speaks to how land is divided, and a capital improvement plan, which has to be developed annually, and it is based on the comprehensive plan, is how you, the government, are going to spend your money and where those priorities are going to be. The comprehensive plan, and I chose to speak on the comprehensive plan because I think if there is one single document that helps your community grow or not grow in the way you want, it is this plan. There is nothing you are mandated to put in. You don't have to have conservation areas. You don't have to have high concentrated growth. You don't have to have agriculture. You don't have to have forest. But you may choose to, and it is a vision of your community, your jurisdiction, in 5-year increments, because every 5 years you have to revisit the comprehensive plan. The goal of the comprehensive plan is to have coordinated and harmonious land development, and to do that, it requires you to survey and do studies and map. You can't look to what we want to be without knowing what is in the present. So the first map you have to draw is what is here now, what inhabits and is on our land now. And then, what if the natural growth of the decisions we made, not the decisions of individuals in your community, but the decisions you have made for the future, how will that comprehensive plan change? And when I was county attorney in New Kent, for example, a decision was made to put a sewer line along the interstate 21 miles. That was in the capital improvement plan as well. And you can rest assured that that sewer line from 21 miles would change the comprehensive plan and should have been consistent with the comprehensive plan, which was to encourage growth along the interstate. It designates the location of roads, historic areas, mineral resources, urban development areas, and other areas of development. It must be based on those studies, and it has to have an analysis of the present and future needs. You, as boards of supervisor members, do not develop the comprehensive plan. This is a role reserved to your planning commission. And in all of land use, your planning commission is going to be bringing you the issues to decide. So who you appoint to the planning commission is going to be key. But it is the planning commission that prepares the initial preparation of the plan, holds hearings, makes the recommendations, and can take it up at any time, but they must take it up every 5 years. And by the way, this isn't a legal document that's enforceable, because it can change, and it envisions change all the time. And it should be looked at periodically. The supervisors must adopt it. Remember I told you to remember the words arbitrary and capricious? When you're called upon to make land use decisions, it is your comprehensive plan that will give you the rational basis for your decision. So when you're looking at something, you always want to go back to the comprehensive plan and say, wait a second, we want this as open space. We want this as agriculture. Developer, your proposal for a subdivision is beautiful, we love it, and it has great merit. But you know, our comprehensive plan says it's in an agricultural area. Well, it doesn't fit. It's not consistent with the comprehensive plan. Now, if indeed you're going to rezone it and change it or allow high-density growth, you're going to have to go back and change your comprehensive plan before you do it. But it gives you, collectively as a whole, and you as individual members, the basis for making your decision. And if you can remember a key word when you're going to vote or you're speaking to an issue, it is consistent or it is not consistent with the comprehensive plan. Make sure your planning staff is always telling you the consistency to that plan. And second of all, your capital improvement plan has to be based on the comprehensive plan. Conformity to the comprehensive plan is mandatory in all your land use decisions. So as you see your community change, or as you envision changes that you would like to bring about in your community, maybe less growth, more growth, whatever it may be, make sure that it is consistent with the comprehensive plan, because the statute says no street, no connection to an existing street, park, or other public area, public building, public utility facility, whether publicly or privately owned, shall be constructed, established, maintained, unless it is consistent with that plan. And all proposed changes in land use must be consistent with that. You can understand why I believe the comprehensive plan. Legally, as an attorney, I want that plan to be my primary defense when the action that you take is challenged. This was done with a basis in fact. It wasn't just out of the whim. It wasn't arbitrary. This is perfectly consistent with the comprehensive plan. And I'm going to end on one note that, not in land use planning, but we have in Virginia a strong movement and strong support for conservation easements. Conservation easements, I personally believe, are wonderful, but it gives the private landowner the right to say, I will get a tax credit if I put my land forever and ever and ever and ever into conservation, be it open space, be it other types of conservation. What does it do to you as a community? What would happen if a 2-mile square area was put into conservation for you? What happens to your taxes on that land? Forever and ever and ever it's going to be low. So the law says that there's no tax advantages to a property owner for putting a conservation easement on if it isn't consistent with the comprehensive plan. So even affecting how individuals will treat their land, the comprehensive plan has importance and significance. I only had 10 minutes. I think I spoke over, but we're going to take at least any number of questions you may have. But it is your map, your guide, your resource for all the decisions that are going to be talked about by my fellow colleagues. And at this point, I'm going to introduce Danielle Cosby, who will tell you about herself. We're all from San Anderson. We're all local government attorneys, and we all have a passion for land use. And thank you.
Well, good morning. Phyllis did not go over time. She held it exactly to 10 minutes. So she is a hard act to follow in many respects, and now she's added one more. So I'm going to try to do equally well. I'm going to be speaking about the subdivision regulation, but also some of the other land development ordinances that you may want to be familiar with just, going forward with the land development process. The ones that I'll be speaking about are mandatory, really, in nature. So there's less discretion, on behalf of the Board of Supervisors for what they can do. But again, they're very important, and they will likely be something that you'll have to deal with over the next 4 years. And particularly, you may be reading, particularly in the stormwater area, environmental protection, is huge. It's going to be big in the General Assembly or regulations coming out of that, so I'm going to touch on that just a little bit. Yeah, okay. So again, subdivision regulation, but also land development. If Phyllis has given you sort of the 10,000-foot view of land development, subdivision regulation and the other environmental statutes are really the on the ground. So you've gone from here to here, 2 minutes. Unlike comprehensive plan, which is just a guide, again, the subdivision regulations are really, the meat of how do you implement the provisions that you've put in your comprehensive plan. So if you want to have coordinated communities and areas, how do you do that? You do that through the subdivision ordinance. Again, erosion and sediment control law will come in really at the site development level, but it's something that's mandatory on localities and it's an ordinance that you have now and may be subject to change later, and so that might come before you. Similarly, the Stormwater Management Act has been getting a lot of press with the Chesapeake Bay protections and new regulations that could potentially affect every locality, certainly the tidewater localities, but have implications statewide, so I'm going to talk about that briefly. And then also the Chesapeake Bay Act we'll discuss. Again, that's a mandatory requirement that needs to be included in subdivision and other land development regulations for the tidewater localities. Again, as we've said, the subdivision ordinance is the way you implement those comprehensive plan visions. Once the guide, this is your plan for getting there. Subdivision is defined by the Code of Virginia as the division of a parcel for the purposes of transferring land into 3 or more lots, or if you've got lots of less than 5 acres each that are being transferred, or whenever in any division a street is involved. So that's the Code of Virginia's definition. Local ordinances can also define subdivisions differently. I know that many localities have major and minor subdivisions, and that's permitted. So, you know, those are very likely already included in your subdivision ordinance, but, you know, just so you know, that's what we're talking about. The Planning Commission, again, as Phyllis said, it's so important to have good planning commissioners, you know, not only because they are preparing the comprehensive plan, so they're at the 10,000-foot level, but then also the subdivision ordinance. They're responsible for preparing that ordinance as well. So again, it's so critical that you have good people that are able to do this and understand your communities. Likewise, they will depend heavily on your staff. So I do a lot of work with planning commissioners and staff and a lot of land development. You know, that's really my passion, I guess. And so, you know, I think that having staff that you trust and having staff who are knowledgeable is also very critical. You know, but also you need to listen to them, you know, when they're bringing proposals to you. So make sure you have, you know, good staff and good planning commissioners. And again, you're going to be getting input from the community for changes to the subdivision ordinance. And as Phyllis described, you know, there's the constitutional requirements of notice and public hearing. Given that, you know, subdivision ordinances have been required for, you know, many years, and you already have one, what would probably come before all of you, you know, are changes that we're seeing coming down from the General Assembly. And those are sometimes, you know, mandatory changes with the types of requirements that must be included for plans of development, for example, or payments for particular improvements. So, you know, I think, let's say, sort of the easier work may have been done. You know, you've already have the subdivision ordinance established. You know, lately we're seeing very high technical provisions, you know, as to who's going to pay for improvements, how we're going to coordinate improvements. You know, for the past several years, you know, since about 2007, you know, once the economy started to turn in 2007, you know, we were in a boom. Transportation was the big issue, how we're going to pay for transportation. And so there were a lot of bills and new legislation that required modifications, you know, considerations in the subdivision ordinance to address that. You know, we're in a different environment now, you know, and so now it's how do we keep the development moving? How do we keep any momentum? How do we, you know, recognize we're in a down economy and allow for developers, you know, the timing of improvements? So again, it's very technical these days. You know, what you might be seeing in your subdivision ordinance, those types of criteria. Again, it's vital to depend on those professionals that are going to bring you these types of provisions. The Board of Supervisors, obviously, you're going to adopt subdivision changes after a public hearing, and then, for the most part, the subdivision ordinance is administered through the Planning Commission and through staff. So I know some localities will, bring subdivision approvals up to the board, but, it's generally done administratively at the, with the Planning Commission. No plat can be recorded until it's been approved. So, that's the requirement. I will tell you that sometimes those slip through, just as an aside, and if it happens, there's a small civil penalty for a property owner who does that. Plats can be vacated. It's, an obnoxious process that does usually require some type of board action in vacating subdivision ordinances. So again, you want to make sure that your planning departments, just have key people that are really keeping an eye on this. The Code of Virginia requires, unlike comprehensive plans, there are mandatory provisions that are required for subdivision ordinances. And as you may expect, those would include the requirement that there be a plat meeting particular requirements also set forth in the Code of Virginia. The plat has to include those provisions, but also show road coordination, drainage, flood control, water, storm, and sanitary sewer, and other public utilities. And it also, the ordinance has to provide for the acceptance of dedications for these public facilities and improvements. And there's also a requirement that the localities all allow for family subdivisions. So that's sort of, another provision. The rest of the mandatory provisions are really related to sort of the planning process itself. And so that is where, again, you are at the plat level now, coordinating your vision from the comprehensive plan, and also for the payment or the timing, of roads. And as Phyllis said, the right to use your property doesn't mean that you can use your property to the detriment of your neighbor. This is how you make sure, or you try to ensure that somebody's development of their land is not going to adversely affect not only their neighbor, adjacent properties, the communities, so that you have anticipated what are the off-site impacts that are caused by this development, and how have you dealt with that. So those are your mandatory provisions. The Code of Virginia also provides for optional provisions that you also may include in your subdivision ordinance, and that includes things like the granting of variances, having approval from the health department before sewage facilities are installed, notices on street standards, payments for off-site improvements, other issues, cluster developments, and environmental assessments. If Phyllis said 2 words you must remember are arbitrary and capricious, I am at 11:20 going to tell you the other 2 words that are vitally important for you, and that's the Dillon rule. And the Dillon rule, of course, as hopefully you know, or you will soon get to know very well, is that if the authority is not in the Code of Virginia or implied or necessary, then you don't have that authority. So for subdivisions, you really have to find the authority in the Code of Virginia. Again, quickly, subdivisions are submitted to the locality for review, the actual plats, and they are approved by the subdivision agent. If they are denied, then the reviewer has to identify why and let the developer try to fix those. Again, they're administrative, and so if they conform, then a property owner is permitted to subdivide their property. Again, plat approval is administrative. There's usually concept plans, preliminary plats, final plats, and approvals remain valid for 5 years. I will quickly touch on erosion and sediment control law, which I mentioned. That's a mandatory provision from the state that localities have E&S programs to protect the environment from sediment and to protect water quality. Those are generally administered by your local staff, so you won't really see those, but know that those are mandatory in your locality. Similarly, the Stormwater Management Act requires now that localities within the Tidewater area take over stormwater management programs, and take over permitting of construction. So that's going to be coming your way for Tidewater localities, and it's going to be mandatory for other localities as well. And again, that's due to some action from the General Assembly in 2004. So localities, that's an issue I think Larry Land will be speaking to you about, but that's something that I hope you'll be paying attention to. And again, there's information, I won't go over all of this because I know we're short on time, but just to let you know what the program requirements, you know, what is being required of you now. That's just to show you the localities that are required to adopt the programs versus those that may implement the programs. And then finally, I'll just end with the Chesapeake Bay Act, which, like the Stormwater Management Act, is required for Tidewater localities, and those localities are required to put design criteria and development criteria into their subdivision ordinances and other ordinances to protect water quality. And again, those land development ordinances are mandatory, but they are subject to change and programs that may come before you. So I wish you the best of luck. It's a changing environment and it's a difficult one, and so I give you all the credit and wish you all the best of luck.
Morning, my name is Jim Cornwell. I'm one of the shareholders of Sands Anderson, and I am going to tell you everything you need to know about zoning in 10 minutes. Sit tight, folks. Let me tell you the first thing about zoning is that unlike some of these other programs and statutes that we're talking about, zoning is actually not mandatory. I serve as county, city, or town attorney for 7 jurisdictions in Virginia, 2 of which do not have zoning. One of which is the Chesapeake Bay County and has a very comprehensive zoning ordinance. The other several have fairly simple to medium type of zoning ordinances. So zoning is what you want it to be in your locality. It can be extremely tight, controlling if the locality feels that it's necessary. It can also be fairly, I won't want to use the word loose, but it can be fairly innocuous. I have one county I worked with that adopted a zoning ordinance that basically said if you're doing what you're doing now, you can keep doing it. You're zoned for it. If you're not, it's all agriculture. So zoning is what you make of it. I started to do this as, you know, David Letterman's top tips, but then I realized that I was going to run out of numbers because I had more than 10. So I'm just going to try to give you some of the basics that you really need to think about in doing zoning matters. The first thing I want to make sure you understand is that the Planning Commission and the Board of Appeals on what Board of Zoning Appeals are what you make them. You get to appoint them. The court appoints a Board of Zoning Appeals, but it's going to be rare that a court judge would not appoint who you recommend. Be careful who you put on these boards, because those are the people that are going to be on the front line in making recommendations to you or in deciding issues relating to appeals that are on your zoning ordinance. I was once in front of a Board of Zoning Appeals making a pitch on behalf of the zoning administrator whose decision was being challenged. And we must have maybe 45 people in the room that were listening to this, and one of the Board of Zoning Appeals members stopped me and said, Mr. Cornwell, I don't understand what we're doing here. I don't believe in zoning. I don't think we all have zoning. Whereupon, in front of everybody, I turned to the county administrator and said, who put him on the Board of Zoning Appeals? And you might want to put somebody like that on the other board, but I don't know if you got an appeal of a zoning administrator's decision, why you would want somebody who doesn't believe in the concept of zoning. So be careful with your appointees to these boards, or they will come back, the decisions they make will come back and bite you. They should be property owners and residents of the county in some respects, and statutorily they have to be, but you should be careful of those appointments. Let the Planning Commission do its work. One of the benefits of having a Planning Commission is to have them do the heavy lifting. They conduct the initial public hearing, and they sort out the appropriate information and make a recommendation to you. Therefore, I do not recommend to my localities that they have joint meetings with the Planning Commission. because there's no time for due consideration. You're sitting there and you're both hearing the information at the same time. The Planning Commission is under some time constraints to make a decision, and they're going to want me to kick a decision over to you that may not be maturely thought out, and then you won't have the time to think about whether to approve or disapprove, or if you approve with conditions or so forth, when you get that recommendation from those people, because everybody's going to be sitting looking at you to make a decision. So I do not recommend a joint hearing. I recommend the Planning Commission be given the guidance, but also be given the time to make their decision. Because they are, in reality, a sounding board for you to receive comments and make recommendations to the Board of Supervisors. You don't always have to take their advice. And make sure your PC Planning Commission members understand that. Because they may get their feelings hurt when they make a recommendation to you to do something and then you eventually vote not to do that. But provided you appoint good people to the Planning Commission, their recommendations should be seriously considered by the Board of Supervisors, because I can promise you their recommendations will be played back to you in the circuit court when that matter is appealed. The Planning Commission looked at this, the Planning Commission considered this, the Planning Commission recommended it, but the Board of Supervisors denied it. So the Board of Supervisors' action was obviously arbitrary, capricious, and unreasonable. When you do disagree with their recommendations, the record should be clear to reflect as to why you disagree. It may be that we felt like the additional information came forth that wasn't in front of the Planning Commission, or whatever reason it is, but the record should reflect that. And don't be afraid to send it back to them, okay? If you feel like it needs more consideration. The most important thing in defending your zoning, and Andrew's going to talk about litigation, but you need to build a record. You should have a good application form. You should have the staff make a report. You should have a good Planning Commission record, and you should always review those documents in reference to the comprehensive plan. The applications, I have kind of a short list here. Have your staff give you the application form they presently have and see if you think it meets your needs and contains all the information you want. You know, one of the issues that many times the application doesn't show is the infrastructure requirements. If you got a subdivision that's going to have 150 lots, but you know there's only a 2-lane gravel road going to it, make the applicant tell you that on his application, so there's no question about it. And make sure you know there's sufficient information in there to start the ball rolling in building your record. Also, make the applicant look at the comprehensive plan and see what his opinion is about why it does or does not fit with it. Staff report. At a minimum, the staff should confirm that all the factual allegations in the application are correct. Provide the site map, provide soil map, provide comprehensive plan information, and review current infrastructure to determine if it will support the project. I also recommend that the staff make a recommendation. Some boards and some planning commissions don't like that. They think it takes power away from them. Well, and sometimes staff recommendations can also come back and bite you when they recommend in favor of a project and you turn out not doing it. But you need to know everything you need to know. You won't need to figure it out that you need to know it until after you have made your decision. So get as much information as you can. If it is a special use permit or a conditional use permit, as some jurisdictions call it, have conditions. Don't just approve a special use permit or a conditional use permit blanket. That's what a special use permit or a conditional use permit is before. If it's a rezoning, recommend approval denial based on the comp plan, infrastructure, soil map, etc. If you don't feel comfortable making the staff report, at least get the staff report making a recommendation. At least get information from them on all of those issues. Always consider and address the comprehensive plan and amend it if necessary. First question in reviewing any zoning application should be, is the application supported by the county comprehensive plan? If it is not, then the application should either be denied or tabled until the comprehensive plan is amended. In one jurisdiction I worked with, that was on the application, the staff had the authority to say to the applicant, if your application does not comply with the comp plan, we cannot recommend this application be approved. We think the project is good, bad, whatever. if you're going to make this application, you should also at the same time file an application to amend the comp plan. Conditions can be imposed on special use. Conditions can originate from the staff report, the application, the PC report, and the conditions must be based on physical operation of the use. We always have this big argument of can we condition the special use permit on the owner of the property, because we know this owner. We don't know who he might sell it to. I think the better answer to that is no. It has to be based upon the physical operation of the use. Consider and address infrastructure necessary to support the project. Review the application at the Plan Commission meeting. If what proffers from the applicant will improve the infrastructure and has the developer offer these improvements, and if he does, can you legally accept them? That's something your county attorney will have to address with you. Consider adoption or review of your ordinance on cash proffers. Many of you know what cash proffers are, some of you may not. That is, if your applicant makes an amendment to the, makes an application for rezoning, he agrees to pay a certain amount of money per parcel to cover capital costs. Because almost any no development will cover the capital costs. They cover the cost of operation, but not the capital cost. Consider a cash proffer ordinance. Consider constant reviewing it if you have it. Don't act in haste and regret at leisure, or you'll wind up with Andrew telling you what the circuit court judge is going to do. Take your time. The Board of Supervisors actually has up to 1 year to consider an application. The developers are going to be in there screaming at you that they need to do it, they need to do it, they need to do it, the time is money and all those good things. Think about it. You have a year, but when it comes on to you to make that decision, due consideration. There are mandatory procedural steps that must be taken. Have your staff review that prior to your public hearing to make sure those mandatory steps have been taken. I've been in public hearings where we found out not all the owners of the property signed the application. Or the guy who submitted the application didn't even own the property. He was just doing it with the hopes that he'd get it rezoned and then he would buy it. You can't do that. If there are procedural defects, stop. No use to want you're going to get beat in court. Any procedural defect is going to be a killer to you. Send it back, redo it, you can go back to the Plan Commission, fix it. Best defense to challenge a zoning decision is that your decision is based on a comprehensive plan and record before you. The application, the staff report, the PC report all constitute the record. By reviewing the record, you gain insight into the consequences of the approval or denial of the application, and you can cite the record in support of your motion and the Board of Supervisors' action to either approve or deny the application. That was everything you need to know about zoning in 10 minutes. Thank you. Now, Andrew's going to tell you how to attend.
Well, that's right. You know, if you do everything Jim said, then you don't need to talk to me at all. My name's Andrew McRoberts. I'm also with Sands Anderson. I do a lot of zoning litigation, tax defense, and other things, as well as, of course, give other kinds of specialized advice to local governments. I will say that I said as a joke that you need to listen to Jim, but I will say that getting good advice during the process is critical. You always want to avoid litigation if you can. Litigation is expensive. Litigation is a hassle. Litigation is a political problem for you, the elected official, and so you always want to avoid it if you can. The second reason you want to get good advice as you go along is the fact that there are right ways and wrong ways to do it. Jim pointed out that you will lose if you have a procedural problem. Well, there's right ways and wrong ways to do it, and you get the advice and you do it right, and then you have those things. The other thing is that even among the right ways to do it, there's ways that are more or less likely to get you sued. And so get that advice, get that insight from a land use attorney, someone that has been there, and that'll be of big assistance to you. As you're going through, just a couple of points before I get to my PowerPoint that occurred to me as I was listening to Jim. The comp plan is absolutely a bedrock thing. I think we've all said that. One of the things that Jim said, and I absolutely agree with this, is the best defense is in court is the comp plan supported what I did. The Supreme Court has absolutely said that that's actually an absolute defense. There was a case involving land use application out in Salem, Virginia, and there was really very little evidence of reasonableness except that it complied with the comp plan. The Supreme Court said, that's it, they win. Supports the comp plan. The second thing about the comp plan that I like to say as a litigation point is the fact that the comp plan rarely 100% supports any application. There's pros and cons quite often. I know in some of the counties in which I've been the county attorney, it would say things like, we really support this residential density in this area over the long-term plan of the thing. There's also chapters in there that talk about preserving agriculture and preserving open space. Well, one says yes, the other says no. A good staff plan, a staff report, as well as a litigation defense, is the fact that yes, there's reasons for and reasons against, and that's why we, the elected officials, end up making the decisions we do. Arbitrary and capriciousness, as has been said, is the absence of reason, the absence of a good basis, in fact, for what you did. And if, in fact, the comp plan says things that are good about it and bad, then you win. And so I would recommend that the staff, as well as the elected officials, don't run from the fact that there's contrary things in the comp plan. But that's why we elect officials, to make decisions on the basis of the whole set of facts, good, bad, and indifferent. That's why we hold comprehensive plan, public hearings, and that's why we have the folks elected that do the tough, heavy lifting like you guys. All right, back on my outline here. Appeals are solely statutory. If there is not a statute that allows a lawsuit against a local government body or a county, then it can't be done. Okay, sovereign immunity rules. You are actually the heir of King George III. I know when you were elected you didn't think that. And certainly we threw off the shackles of King George III back in the 18th century successfully. We're very proud about that. But in fact, the sovereign immunity that the king had imbues through the Commonwealth of Virginia to you, the political subdivision of the Commonwealth. And so if there's not, in fact, a statute that says this person may sue you, then you can't be sued. And the other part of that from a litigation point is they must follow the statute strictly. Okay? I'm going to talk about BZA appeals for a little bit. That is decisions of your zoning administrator. That might be someone whose title says zoning administrator. In very rural places, it might be your county administrator who carries that out. It might be in larger places an assistant or a deputy of some sort. Circuit court, of course, hears appeals from BZA decisions, but that's also where folks go to challenge zoning decisions as well. And also circuit courts hear disputes, litigation over things like subdivision approvals and things like that. First, we're going to talk about zoning decision appeals to the BZA. The statute allows any decision, determination, order or requirement to be appealed to the BZA. The BZA acts in a quasi-judicial fashion, which means they put on the black robe and the powdered wig, and they get to act like, sort of like judges. That's what quasi-judicial means. They get to act like judges. They hold a hearing. Both sides get to come and get to present evidence and information, and then the BZA makes a decision. And then when their decision is made, then any person that is aggrieved gets to appeal that within 30 days. There's a very tight window. And then when a zoning administrator makes those determinations, those determinations get appealed to the BZA as well. There's these 30-day windows you'll find throughout the zoning code. One of them is a zoning determination gets appealed within 30 days to the BZA. BZA appeals within 30 days to circuit court. Your decisions of zoning matters, zoning applications, CUPs, SUPs, they get appealed to circuit court within 30 days as well. Those tight deadlines are in order to have finality and to move things along because people's property rights are involved. One of the exceptions to the rule, I said generally zoning determinations of the zoning administrator go to the BZA. Well, there's one appeal that goes to you, the elected officials, and that is a proffer interpretation. If in fact there's a proffer, and Jim addressed proffers, which are zoning conditions attached to a zoning application, once they're accepted, they become additional zoning regulations on the property. If the zoning administrator interprets that and enforces that against the landowner gets to say, but wait a minute, I didn't submit those zoning proffers to you, the zoning administrator. I submitted to the governing body. I get to go to them and ask them what it really meant. And so you may, from time to time, see one of these appeals. And it's kind of strange because typically zoning appeals do go to the BZA, but this is one of the creatures that actually comes to you. Once a BZA makes a decision, I said they're quasi-judicial, they wear the powdered wig, those appeals within 30 days go to the local circuit court. There's a complex statutory process. I told you appeals are solely statutory in 2314, where there is a petition by an aggrieved party. The aggrieved party might be the landowner who didn't get what they wanted, or it might be someone that's asked for a zoning determination that didn't like the result. It might be you. Zoning, BZA might have done something that you think is inconsistent with what you think the meaning of the zoning ordinance is. You might be the aggrieved party, or the zoning administrator might be the aggrieved party. It may also be a neighbor that is fundamentally affected. In any event, once the person is aggrieved and they have filed within 30 days, it goes up to circuit court. And then the circuit court will make a decision. The statute was amended about a year ago to provide who the necessary parties are. And you'll see my last bullet over there. Guess who the first necessary party in a BZA appeal is? You. You get to be a necessary party, which means you, through your county attorney, will be served with papers of every BZA appeal. Now, that doesn't mean that you have to take an active role. For example, it might be a variance or some other kind of issue that you just don't care about. Then the county attorney can maybe file papers and just accept the result or default or whatever your legal position is. But you will be named, and so you will have an opportunity in every single one of these to take the position that you like through your attorney. Appeals directly to circuit court. When you make a zoning decision, and Jim told you the process through that, once you rezone something or deny a rezoning or approve a CUP or SUP or other special exception, within 30 days, if there is a challenge to that, it must be filed within 30 days. And if it's filed within 30 days, then it proceeds. If it hasn't, then they're out of luck. And that's really a very good thing for you, the governing body, which means that you'll know very quickly if you're going to get sued. You don't have to sit around and wait for 6 months or a year and say, well, they might sue us someday. They're going to sue you right away, and you'll know about it within 30 days. And then you can take appropriate action. The other good thing about that is if you're being sued, it's likely been a fairly contentious case. And so it's very fresh on your mind, and so you can move forward with it. I will say that one of the special cases involving determinants of vested rights, instead of going to a zoning administrator for a determination of vested rights, applicants and landowners can go directly to the circuit court. There was a sort of question as to that, but I know there's folks from Stafford in the room. You guys resolved this issue in the Crucible case as to the fact that you don't have to go to the zoning administrator to get a vested rights determination. You can go straight to circuit court. One of the things that vested rights do is protect the landowner to finish a project despite a change in the zoning. But it also protects the governing body. If y'all have made an approval, but yet the law has changed somehow, you want that project to finish. So it really protects everyone's interests and expectations. Declaratory judgments actions. If there is an action filed within 30 days, as I told you before, in the circuit court challenging your zoning decision, then there is a filing in a declaratory judgment action in circuit court. What the statute says, in cases of actual controversy, circuit court shall have the power to make binding adjudications of right. Controversies involving the interpretation of statutes, municipal ordinances, and other governmental regulations may be so determined, and the citation is there. That is the vehicle, along with specific zoning statutes that say, yes, you may sue within 30 days, that people use to challenge your decisions. A couple of things about deck actions is you have to have an aggrieved plaintiff. Not just any taxpayer or citizen gets to sue you in a deck action. There has to be actually some fundamental right or interest impacted by your decision. Typically, that is in Virginia called standing, and there is a common law definition of standing that says that they've got to have something more than just your basic interest as a taxpayer or citizen. They've got to have some right. They've got to have some interest that's different from everybody else. What that typically means is your decision has to impact them in some special way. Maybe they're a neighbor. Maybe they have a business or contractual interest. Maybe they have a property right of some kind or a contractual right of some kind. The plaintiff has to point to that or else they get thrown out of court. The Virginia Beach beautification case is one of those cases that talks about standing and what you need and essentially the denial of some right. Okay, I'm going to wrap up. They are supplemental to existing causes of action, so if there's some other kind of an appeal that's permitted, you must do that, not file a VAC action. And if they're moved, you don't do that. Essentially, okay, I already did this. Essentially, courts in litigation on appeal will defer to your decision if there is some reasonable basis. We talked about arbitrary capriciousness. We talked about the comprehensive plan. The deferral on substantive matters is a very powerful thing. You are the local legislature. And as the legislature, the courts are going to generally defer to your decision because you are elected to make that decision. I told you from the beginning, there's often good arguments on both sides. That's why it comes to you, and that's why the courts will defer to your thinking. If it's substantive, it's a procedural, as Jim said, you better watch out. And that's our presentation, and we'd be glad to have questions. Thank you.
Any questions about land use? Very simple topic, very non-controversial.
My question is about the Planning Commission. Would you describe how they relate to the Board of Supervisors and who has the authority to change the size of the Planning Commission?
Do you want to answer?
The Planning Commission, how they relate, a lot of it is interpersonal relationships. I mean, as I indicated in my presentation, it's important that you be careful on who you want on the Planning Commission and that you carry forward, what your individual goals are and those goals are for the county. Changing the size, there was a statutory proceeding to appoint additional Planning Commission members. There's also a statutory proceeding to reorganize the Planning Commission. There is some issue about whether you can wipe out the Planning Commission and reconstitute them because they do have terms of office, but there are some cases out there in which you can't do that. Again, it's important, and I'm not just talking about the Planning Commission, we're talking about every appointee you have. It's important for you to be careful about who you put on these boards and agencies because you're going to live with them, and they do a lot times a lot more than you do. So you should know your constituents and you should know people who you're appointing to these agencies. Hope that helps.
Question over here.
Before we take that one question, there's one other piece on the Planning Commission. You can set terms, and sometimes setting a shorter term allows the turnover, and that may or may not be good. But you do set those conditions, and I was given a note that I made a mistake, and I learned very early in life that you own your mistakes. My mistake was I said there were no mandatory requirements in the comp plan, and there is one for 45 counties, and that is urban development areas, and you have to make provisions for them. It doesn't. So I want to apologize to you for being mistaken, and now we can take the question.
Who do we go to if we feel that there are violations from a developer regarding erosion and sediment control law, or if they're not following our outdated comprehensive plans not being adhered to under the disguise of agricultural development?
With regard to the first part on the ENS, your local staff would be enforcing that. So there are mechanisms and penalties that are written into the state law. So depending on what the violation is, if it's for land disturbance over 10,000 square feet, they're required to have an ENS plan. So if they don't have a plan, that would lead to a penalty. If they've got a plan but they're not in conformance with that, then that would lead to potentially other penalties. So your local staff would be the ones who are enforcing that, and that would be through a notice of violation, and then penalties, either civil or criminal, you know, as you've included in your ordinance. And the second part of your question, I'm sorry.
Will they not follow the comprehensive plan of using agricultural development disguise, and if we know eventually down the road they're going to plan development, that's not falling under our comprehensive plan?
Well, that sounds like a zoning violation then. I mean, if somebody is using their property in a way that it's not zoned, so if, you know, if it's agricultural and they're doing something that's more intense development, then similar, that would come from your zoning administrator would issue that notice of violation, and the same thing. So issue the notice of violation, give them at the bottom of it the right to appeal it to the VCA, and if they appeal it, you go that route. If they don't appeal it, you know, the good thing is it's legally a thing decided, and you know, and they've lost their appeal rights. So,
Question over here.
This is probably a little more nuts and bolts than what we're talking about today, but invariably, those of us, particularly in rural areas, get two arguments in the negative when you have a rezoning. And one of those arguments is, this doesn't fit the comp plan. Of course, we've addressed that a little bit this morning. The other one is, this is spot zoning. You can't do this, this is spot zoning. Could you address a little bit, what is spot zoning? When is spot zoning spot zoning?
It's Andrew's turn.
Thank you very much. I hope I'm not going to pull this out. I hear that all the time, and that's a very good question. Spot zoning, from sort of a common sense perspective, would be any zoning that's inconsistent with the zoning around it, right? That's what we all think spot zoning is. Legally, that's not what the Supreme Court says it is. Spot zoning is actually a zoning decision that's not in support of the overall comprehensive plan for zoning. In other words, it's something that was done for a particular landowner and against the interests of the citizens of the community as reflected in the comp plan. So when people stand up and say this is spot zoning, sometimes it's helpful to call upon your county attorney for a legal definition of spot zoning, and I found that that can be helpful to sort of redirect folks, because zoning all the time is inconsistent with zoning around it. Anytime you come in and say, I want to rezone this from residential to business, for example, that may very well be inconsistent with what's around it. But is it supported by the comprehensive plan? Is it in the interest of the health, safety, welfare of the citizens? That's the question.
There's a question over here.
Yeah, can you give us your thoughts on how we deal with the emerging issues surrounding the UN Agenda 21?
Let me give that a shot.
That should be held for another time.
Okay. Well, I have a county that doesn't have zoning, and I listened to 2.5 hours of attacking the comprehensive plan for that very reason. When the whole intent of the comprehensive plan, the strongest language was that the Board of Supervisors should adopt a study, should appoint a study commission to look at such and such. So I am aware of those issues. So, but there will be other.
With proffers, are they available only if, let's say, on a piece of commercial property? If it's already commercial and you want a commercial use to come in there, are there proffers available for that, or strictly proffers available only for rezoning property?
Proffers have to accompany a rezoning application of some sort. I have seen the circumstances under which a governing body initiates a zoning, and then the landowner comes in and willingly proffers within it. Anytime the landowner in a zoning situation is willing to proffer conditions, they are able to do it. Many counties have the ability to accept cash proffers, some do not, but all counties have the ability to accept on some basis proffers.
There's also a little known section of the code that allows you to have plans of development to be approved prior to issuance of a building permit. One of my jurisdictions exercises that right in a rezoning to a commercial district. They make them submit a plan of development because they got tired of approving one type of business.